Welcome back to the deep dive. So if you've been following the news at all over the last, say, decade,
Two.
or 2 decades, yeah, you've probably absorbed a certain story about the European Convention on Human Rights, the ECHR.
Right. And for most people, that story is pretty clear. The ECHR is, a modern thing. It's a foreign thing.
A foreign imposition, yeah.
It's this distant court in Strasbourg with these unelected judges, and they're sort of interfering with our laws. It's always controversial.
Especially around things like immigration or security or deportation. It always feels like this external force.
Exactly. Something that happened to the UK.
Right. It's positioned as this vaguely bureaucratic, slightly annoying thing that chips away at sovereignty one headline at a time.
Well, today we are diving into source material that just completely upends that entire narrative.
It really does.
Our sources suggest that to understand the modern drama, you actually have to ignore the last 20 years. You have to go back to the 50 years before that.
And we promise you, this is a full reframing. The ECHR was, it seems, fundamentally a British creation.
Conceived by Britain, mostly drafted by Britain, and then the UK essentially forgot it even owned the thing.
Okay, let's unpack this. The true genesis of the ECHR.
To do that, we have to go back, way back.
Yeah.
To 1945. The war has just ended.
And Europe is, it's in ruins. Physically, politically.
And the single defining feature of the continent at that moment was, well, a profound and totally necessary distrust of governments.
And for very, very good reason.
Of course, people had seen, with their own eyes what happens when state power goes completely unchecked.
This wasn't some abstract legal theory. This was raw, lived experience of states turning on their own citizens.
Precisely. And this is where our source material delivers its first real shock. Because you'd think, wouldn't you, that an effort to create some kind of pan-European human rights safety net would come from,
Idealists, federalists trying to build a new united Europe.
Light-eyed idealists, yeah. But the sources are absolutely insistent. The people leading this charge were not the Euro-federalists.
So if it wasn't them, who on earth was it?
It was us. The sources point squarely at the UK establishment.
So this wasn't being forced on the UK at all. It was coming from the UK.
It was coming from a very pragmatic, post-war British worldview.
Yeah.
We're talking about figures like Winston Churchill.
Churchill.
Yeah. Even though he was out of power by then, he was passionately banging the drum for it. And maybe the most telling detail of all.
Go on.
British lawyers did most of the actual drafting.
Wow.
The foundational document itself was written mostly by them.
Okay, that context is staggering because Britain already had its own common law, its own protections. Why did we feel the need to write these rules for everyone else and for ourselves?
It goes back to that pragmatic necessity. The British thinking, as the sources lay it out, was basically, our system is pretty robust, but what about the rest of Europe? If we, as a stable democracy, create and submit to a legal framework, it sets a standard, a baseline that these new fragile democracies have to meet too.
So it wasn't about integration. It was about preventing another Hitler.
It was about preventing totalitarianism from ever coming back. It was less a vision for the future and more like
extremely practical post-war maintenance?
That's the perfect way to put it. It was not an ideological project. It was a procedural safety mechanism. And you can really see that practical, almost understated approach in the document itself.
Yeah, the sources call the original ECHR a very British checklist. And that phrase just clicked for me. It really grounds what it was all about.
It does.
So what was actually on this checklist? Was it anything revolutionary?
Not at all. It was the absolute nuts and bolts of civil liberties. Things that, frankly, British common law had protected for centuries anyway.
So we're talking about what?
The right to a fair trial, a ban on torture and slavery, freedom of thought, and crucially, making sure governments couldn't just lock people up because you fancy it.
The right to liberty.
Exactly. None of it is dramatic. It's the absolute bare minimum for a civilized society.
The rights were designed to be foundational, not transformative.
Yes. The source's analogy for this is brilliant. It says the ECHR was more, let's put the fire extinguisher in place while the house is being rebuilt.
Ah, I love that. It's not the grand architectural plan for the house.
Nope. It's just making sure the basic safety gear is installed before anyone moves back in.
So the key takeaway for you listening is that the ECHR at its birth was basically a UK-shaped thing. It was designed as a sensible bit of post-war housekeeping, not a revolution.
Right. And Britain defines it, drafts it, promotes it. 1950, the convention is signed. 1951, the UK formally ratifies it. The court gets set up in Strasbourg. And then,
And then nothing.
A very, very long period of silence.
And that silence lasts for almost 45 years. That, to me, is the most profound part of this whole story, given how noisy it is today.
For almost half a century, the ECHR was maybe the quietest international agreement the UK was ever part of.
Why? I mean, why was it so quiet?
Because the UK system was already, by and large, compliant. We had strong judges, a sovereign parliament, established common law. The fire extinguisher was on the wall, but we just weren't having many fires.
So we had the safety net, but we were barely stumbling. It was really designed for other, less stable countries.
Correct. The court in Strasbourg heard cases, of course, but there were hardly any UK cases that went all the way. And crucially, at home in the UK, there was zero controversy.
No one was talking about it.
No one. There was definitely no one yelling about sovereignty. It was just a bit of bureaucracy running quietly in the background.
So if it was so uncontroversial that, as the sources say, hardly anyone in the UK gave it a second thought, how did we lose the memory that we wrote the rules?
Well, that's the irony, isn't it? Institutions change, people move on, and if something isn't causing a problem, it just fades into the wallpaper. We basically outsource the enforcement of our own standards to a court in a different country.
To Strasbourg.
And because we so rarely had to deal with it, we forgot we were the primary author. It was just boring, compliant bureaucracy. Until one day, it wasn't.
Okay, so if Britain set the rules, signed on the dotted line, and then barely broke them for 50 years, what happened? What changed in the late 90s to turn this sleepy post-war agreement into a political weapon?
Right. Here's where it gets really interesting.
This is the turning point.
The turning point, according to all the source material, is the Human Rights Act. The HRA passed by Parliament in 1998. And we had to be super, super clear about what the HRA did and what it didn't do.
Okay, lay it out for us, because this is where all the modern arguments really begin.
Okay, so what the HRA wasn't, it did not invent a single new right. Not one.
So it didn't add anything new to that original checklist?
Nothing. It did not give any new power to the European judges in Strasbourg. The rights of the HRA were the exact same rights fair trial, no torture, that Britain had signed up to back in 1951. The substance was identical.
So the rulebook itself didn't change at all. It was still that post-war, pragmatic British checklist. So what did the HRA actually change?
It was a purely procedural change, but it was an explosive one.
How so?
Before 1998, if you thought a UK authority had violated your ECHR rights, your only option was this incredibly long, expensive, and difficult process.
The trek to Strasbourg.
The trek to Strasbourg. And for a normal person, just think about that. The cost, the time, international lawyers. You could wait 5, maybe 10 years for a result. It was a huge deterrent.
So only the most serious cases ever made it.
Exactly. The HRA just swept all of that away.
It let you use those exact same ECHR rights, but in a British court.
Precisely. In front of a British judge with a British lawyer. The power didn't shift to Strasbourg, it shifted domestically. And that meant that suddenly any decision the government made, the Home Office, a local council, the police, could be challenged right here, right now, using those ECHR rights.
Then that localization, that's the inflection point. The moment the convention became useful for day-to-day arguments.
People started noticing it.
That's the definition of going from background wallpaper to front-page news.
It is. As long as the ECHR was this distant treaty, it was fine. But the moment a UK judge started ruling against a UK minister's decision,
using the rights Britain itself wrote,
that's when it started to feel political. It stopped being an invisible treaty and became part of actual day-to-day legal arguments.
And that's where the friction starts, because the public perception shifts. It's no longer we're a law-abiding nation. It becomes we are being overruled.
Yes, even though we're being overruled by our own rules, applied by our own judges, the debate stops being about the principle of the right, which everyone agrees on, and becomes about its application to really tricky modern political issues.
Like deportation cases.
Exactly. Things like the right to a family, like Article 8, which is crucial in those cases. The rights themselves didn't change, but their domestic power and political profile changed completely.
So that brings us full circle. All the current political drama, the headlines about activist judges, the feeling of foreign interference, it's all actually really recent.
It's a post-1998 phenomenon.
And it all stems from that procedural decision to bring the ECHR's original British drafted rights home.
The core surprising facts just don't change. Britain was the primary architect. Britain signed it. And for decades, it was a total non-issue.
It wasn't some foreign imposition that popped up to frustrate us. It was a British idea that we eventually domesticated.
And that forgotten history, It really should change how we look at the whole debate today.
It really should.
It does. And our source material leaves us with one last, really fascinating question for you to think about. Before we all get tangled up in the current political arguments, just consider this.
Go on.
If Britain wrote the rules, and for 50 years we've barely lost any cases,
Yeah.
why has it all become so controversial only after we made it easier and more local to challenge the government? The author makes a compelling point. The numbers do not match the narrative we've all absorbed.
A question well worth pondering. Thank you for joining us on this deep dive.
Thanks for listening.